The third section of the interview basically moves on from the topic on the inequality of the employment relationship and the internal resolution of problems between the employer and the employee. One interesting thing that Mr. Peku said that I'd like to discuss quickly is he acknowledged that there will always be a tension between the employer and employee due to the nature of their relationship, because each side, as he kind of explained it, has its own interests. They both would like to earn a return on investment that is higher than the initial investment. They'd like to walk away with more than they had. Right? So, I mean, yeah, that's that goes without saying. But my query here is just that has nothing to do with the inequality, though. There is a tension. There should be a tension. The employee comes to engage in establishing this employment relationship for his or her own reasons, and so does the employer. That's a normal tension. That's why there should be a negotiation. So the tension is not the issue, and it's not the problem. The problem is that there is an unequal power balance between the two when they come together to conduct this negotiation. And this inequality benefits the employer, and it's state sanctioned by law. So it's effectively, it all boils down to, again, the employee finding a way to organize so that they can take back their power, right, and become actual participants of economic development, of the economy. Employees are not participants of the economy. They're not really. They are cattle that is herded between employees. They move around farms, right? They're not involved in the farming economy. They are the products. Well, they are the, I wouldn't say the product, but they are the tools of production. The market is a market of productive tools, of which the farmer seeks the best tools in order to net the highest returns. At some point in this section, third section, I asked Mr. Peku Molefe, wouldn't it be better if the testing of the fairness of the internal resolution process happened at the internal stage, not happened once the internal stages had failed, right? Wouldn't it be better if the CCMA was not needed for it to happen? Couldn't the employee or the employer working together to try and resolve the issue internally, test the fairness of the process, right? So he then spoke about a mechanism that's available to the employer, mind you, only to the employer, and that is the hearing. So he speaks about the employer can basically set up to have a hearing on the issue, on the conduct, in most cases, conduct of the employee, but a hearing on the dispute, okay? And for this hearing to take place, it needs to have a chairperson, a neutral person who's going to basically do the function of the CCMA when conciliating after the internal dispute resolution process has failed. So within the internal dispute resolution process, the hearing is a mechanism of this process, and there should be a neutral person who is somewhat like a commissioner, but not actually a commissioner. And this person, firstly, the hearing is set up by the employer. Okay? This independent chairperson is appointed by the employer. So essentially, this whole internal resolution process, like this mechanism, the hearing, is an employer mechanism. It's not a mechanism for both. It's an employer mechanism, but argues legally that it is for both because the chairperson is neutral. But in most cases, the person that's appointed by the employer as chairperson is an employee of the employer, right? Who is expected to take off his hat or her hat as employee when they sit as chairperson in this hearing process. Now, you ask yourself, to what degree can a human being really separate themselves from the relationships in their lives? In this case, from the relationships in the workplace. How far can they seriously separate themselves from there? I do mention actually in the interview, I think I mentioned it in the fourth section, where I say, it's the same case with objectivity when it comes to journalists, right? Just how objective can a human being be when you're reporting on issues that affect your society, your community, right? And, I think it just speaks to the veracity of this mechanism and of this whole thinking around really reaching a dispute resolution, a genuine dispute resolution between two unequal parties. How is that really supposed to work? The hearing is the employer's, the chairperson is appointed by the employer. There's serious question marks here, practically speaking. But it does mention that some employers do offer an employee they hire in their employment contract that they have a choice to select an outside an outside hearing chairperson to come and sit. And usually, not that always, but that person can be a CCMA commissioner, right? The CCMA commissioner coming to basically arbitrate the hearing. And they're being paid. In this case, he did mention that the payment comes straight to the CCMA, not the commissioner, him or herself. So it's the employer who would have. The employer is the one who offers the employee this opportunity, and therefore, should the employee consent, if it's part of the employment contract, then the employer can appoint when the situation arises. The payment comes from the employer. Who pays the outside hearing chairperson? Who pays that person? I would expect that it is the employer, as is with a normal hearing chairperson who's an internal hearing chairperson. That person is an employee of the employer. So in the case of getting someone from the outside, that person is still working for the employer anyway, because the employer is the one that's going to be paying him or her. So, I don't know, conflict of interest? I don't know if I understand that concept properly. And, I think it just speaks to the veracity of this mechanism and of this whole thinking around really reaching a dispute resolution, a genuine dispute resolution between two unequal parties. How is that really supposed to work? The hearing is the employer's, the chairperson is appointed by the employer. There's serious question marks here, practically speaking. There are serious question marks. But it does mention that some employers do offer an employee they hire in their employment contract that they have a choice to select an outside an outside hearing chairperson to come and sit. And usually, not that always, but that person can be a CCMA commissioner, right? Yeah, the CCMA commissioner coming to basically arbitrate the hearing, and they're being paid. In this case, he did mention that the payment comes straight to the CCMA, not the commissioner, him or herself. So it's the employer who would have, the employer is the one who offers the employee this opportunity, and therefore, should the employee consent, if it's as part of the employment contract, then the employer can appoint when the situation arises. The payment comes from the employer. Who pays the outside hearing chairperson? Who pays that person? I would expect that it is the employer, as is with a normal hearing chairperson who's an internal hearing chairperson. That person is an employee of the employer. So in the case of getting someone from the outside, that person is still working for the employer anyway, because the employer is the one that's going to be paying him or her. So, I don't know, conflict of interest? I don't know if I understand that concept properly. One thing I did mention, I did compare the dispute between an employer and employee to that between a husband and wife, because this term internally, solve this matter internally before you call the CCMA. What does that mean internally? And judging from the powers that the employer has at resolving these matters internally, having power over the hearing process, having power over who to appoint as chairperson, it's clear to me that internally refers to internal to the business operation. It's not internal to the employment relationship. Whereas I said, look, if a man and woman are married and the man has bought a house, he's the one who bought the house, right? Should he have a problem with his wife? Does it matter who bought the house? All right? And that's a rhetorical question. The answer is no. Because the point of the relationship between the two isn't the house. It is the marriage itself. The marriage is the relationship. The house is just a venue. It doesn't matter who bought it. They still have to solve that problem themselves. Right? Of course, a marriage is different in one or more ways. So it's not a one-to-one. But my point is that there's a certain dynamic that has to be assured between the two of them in order for their marriage to last. It cannot be one-sided completely. It cannot be. Now, what is the answer that I would have for the employee? Again, read the golden egg at Workers Resolve. I have my answer there, right? But yeah, essentially I was just trying to question this. What do you mean by internally? And to me, it's internal to the employment relationship, not internally as in the business, in the domain of the employer. Because the business is considered legally is owned by the employer. It's their domain. So they're the ones that are expected. That's why they're the ones who are expected to be the farm owner and runner. And the employee is just one of the stock that's being housed there. So to resolve a dispute between two people whom you're trying to equalize, but say that the employer is ultimately the one responsible for resolving that issue, takes away a lot of power from the employee, in my opinion. One of the other issues we discussed had to do with essentially I asked him about the process of labor legislation being promulgated. How are these laws made? What is the process by which laws are made? And we touched upon, essentially my point here was to say that employees, and especially non-unionized employees, don't have the ability to participate in this process of making laws that will affect them and their livelihood. They don't have, the employment contracts inhibit them. I mean, I write about this in my article. They inhibit them. There are certain expectations over and above their legal obligation as per their employment contract that they must satisfy in order to just keep their jobs or in order to hope for promotion. And that keep them basically bogged down with tasks and responsibilities that take away from their ability to add to the debate on labor issues. And he terms the groups that are involved at NEDLEC's debates around labor law, labor legislation, and how it should continue or change, and so on. NEDLEC seems to facilitate this whole process, right? He talks about the groups that participate in these debates as social partners. So these are social partners of the state. Social partners of the state. And I would imagine that these are all organized groups of participants in the market, right? Labor unions, recruitment agencies, employers. So, but employees are not there. Employees are not there, and unions, unions are there. They do represent. I don't want to take that away from unions, but if you read my article, I have a problem with unions, and unions, to me, it seems like they function more like political parties. They have the same challenges as political parties, which if you look at how long unions have existed, I don't feel like they do anything to change the fundamental relationship between the employee and the employer. I don't think they do anything, because if you look at the current South African market, I'm not talking about the fact that the economy is crashing and so on. I'm just talking about the power relations, right? Employees are not even considered a social partner. Employees, it's unions considered social partners. And, fundamentally speaking, I think it's a problem. Once you have to separate a union from the people it represents. We speak about unions, not employees. Unions. That in itself should tell you there's a problem. I mean, what is a union? It's meant to represent its workers, but it's its own organization as well. So is the union the organization, or is the union the employees it represents? Or is a union an organization that represents employees? Like, what is it? Just like a political party. Is a political party the people it represents, or is it an organization that claims to represent the people, but actually it has its own interests that are separate from the people, or from those of the people? This is why, political parties have a problem, because they have an identity problem. Who are you exactly? Are you the people, or are you representing the people? If you're representing the people, then you're not the people. And if you're not the people, then you have your own agenda that the people might not even agree with. And if you do that, then should you be representing the people? Because you are mainly representing yourself. This, I believe, this is the trap that unions have fallen into. They are not their employees. Unions are not their employees. They are organizations that place themselves first, as they should, because they are organizations, right? But I'm just saying that doesn't really work well for the employees. Not in the long run, in my opinion. I still believe, though, they are still a step in the right direction, right? In principle, they're a good idea. That's what I think. Mr. Peko Mulefe then basically goes on to allude to the sophistication of the employee, which is something that I agree with him a whole lot. It basically places responsibility on the individual citizen as an employee to say, look, you need to make sure that you become sophisticated enough to be able to assert your rights, to be able to assert your power, to be able to take back your power. You have to be able to harness your resources, your relationships, so that you can better represent yourself. Now, having said that, one individual sophisticated employee won't achieve much against a system such as the market as it is, as it functions, right, with the help of the state or facilitated by the state. In fact, the market, I would argue, largely punishes sophisticated employees for various reasons. I wouldn't say that completely objectively. Obviously South Africa, and as do a lot of places around the world, still suffer from other issues of discrimination and so on and so forth, and reasons why certain people want other people, whatever, corruption basically. In and out, in group, out group mechanisms of, social mechanisms. So, but I do feel that although the employee should be sophisticated in understanding what it is that they're getting into when engaging with an employer to establish an employment relationship, they cannot do it alone. You cannot do it alone. And in fact, it is impossible alone, right? Employees need to become a social partner. That's what employees need to become, where there isn't a distinction between the employee and the organization that they form into to become a social partner. There shouldn't be a distinction. There shouldn't be.
Lucas.